Hello everyone, Stephen Morris here with Advisory, and today we have a very exciting topic here around what happens to your real estate after you die. And today I have Afshin Asher here with the Asher Law Group, who is the preeminent estate attorney here in Los Angeles. And he's gonna walk us through what happens to real estate after you die, including considerations around estate taxation, probate, and what happens eventually with property taxes, especially in the state of California. So with that in mind, please let us know a little bit about yourself, a little bit about your group, and what you do pretty much.
Well, thank you so much for inviting me. This is exciting. I'm Afshin Asher. I am an estate planning attorney. We handle all facets of estate planning during life and after death, the happier stuff and not so happy matters. We deal with death and taxes. And unfortunately, it seems like neither are avoidable.
Neither are avoidable.
Time. So I've been practicing law for about 27 years, all of it in the field of estate planning. I'm certified as a legal specialist in estate planning, and I also have a master's in tax law. A lot of estate planning is tax driven.
Yep, and we're talking like we're moving into the 2000 section of the tax code, a little bit further along than what we usually engage in, and that's why we bring in the experts to really get this planning going. So let's dive right into it. What happens to your real estate after you die?
Well, a lot may happen or not happen depending on the circumstances. Your real estate may go through probate if assets are in your individual name, or they may not go through probate if they're held in joint tenancy or community property with right of survivorship or in the trust. The property taxes in California may get reassessed or they may not, depending on the circumstances. Depending on the size of your estate, your heirs may have to pay estate taxes or they may not. So it's a facts and circumstances situation all the time.
Then let's go into each one of them. What the heck is probate?
Probate is essentially the act of transferring assets when the person who is the transferor is no longer around to sign a deed over. The person that can transfer the assets for you is a probate judge. And as you can imagine, a probate judge is not just going to transfer assets just because you ask them to do so. There's a process to go through. They want to make sure that all the heirs are notified. They want to make sure all the taxes are paid, the creditors are paid off. There's nothing fishy going on, nobody's being taken advantage of. And then once they're convinced that everything's up and above, then they'll transfer the assets for you. Unfortunately, that takes a year and a half, sometimes longer.
Why? You put in your will, you say it goes to my kids, we're done, right? Doesn't it just transfer automatically?
Well, that would make sense, but no, because again, you're not around to sign that. Even though you said you wanted to go to Bob, you're not around to sign that deed for it to go to Bob. So it has to be the judge that does that.
Okay, and that's a very important consideration. I'll tell you, there's been times where we've made offers on real estate and it turns out the seller actually never had title. They inherited the home from their grandmother, but without going through probate, without having some sort of trust in place, without any sort of mechanism, they're actually not even able to convey title.
Actually, they haven't inherited it. There's a piece of paper that says they're supposed to inherit it, but until it's transferred to them, they haven't inherited anything.
They can't sell it, they can't do anything with it.
Not at all.
Okay, and that's a huge consideration. Just because you think that, like, you know, your mom and dad left you a piece of property, it's not yours yet until you do some steps. Does this happen automatically, or does someone have to take some sort of initiative to get it going?
Someone has to file the petition for probate.
Right.
It has to occur in the county where the person lived or the majority of the assets were located. Yeah, it has to be initiated by a petition for probate.
Okay, so you just sit here and do nothing, you think it's yours, you're still living in the house, no one's bothering you. You're not quite there yet. You gotta do something.
That's really putting your head down in the sand there, because you're supposed to notify the county assessor when there's a change of ownership, your income tax reporting changes, and certainly you have to actually acquire legal ownership. And it makes it more difficult also to insure when you don't have title.
That makes perfect sense. So why go through this legal process here and try to protect yourself from this outcome? Are there costs involved with probate? How long does it take? What's the ultimate outcome of this whole process?
Well, first of all, I want to convey that it's not the end of the world. Sometimes we have to go through probate and people survive. It just takes some time. Like I said, in LA County, it's taking about a year and a half.
Okay.
Sometimes 2 years, sometimes longer, depending on how messy it is. but at the end of it, you'll get through it. So we do want to avoid it. It typically costs about 4-5% of the value of the assets, and I'm talking about the gross value. Oof. So if there's a property that's worth $1 million and you owe $900,000 on it, it's not 4% on 100,000 of equity, it's 4% on the million.
Okay.
And so forth.
Yeah, so that's a lot of money. You're talking 40 grand for 4% on the $1 million and 2 years. So you might miss the market if you wanted to sell the property at a certain time, right?
Well, once a executor, if you have a will, or if there is no will, an administrator, essentially the same thing, is appointed by the court, then you're able to sell the property within the probate. Depending on how much authority you get from the court, that will impact how simple or complicated it is, whether you have to auction the property in the courthouse or not. But you can sell it during probate. It's not totally locked up.
Okay, and now let's talk about that auction really briefly, because sometimes you're gonna see people say, you know, the best way to get a fire sale on real estate is through probate. They do a probate auction, it goes through court, and there are circumstances where investors will come in and get it at a price because either the market was sleeping on it, not everyone's aware of this entire process, there's a lot less potential buyers out there. Maybe you wanna walk us through a little bit on how that whole process works.
Actually, sometimes I've seen that the auction process has worked out okay. Usually what it entails is you list the property and you get an offer accepted, but you tell the person who made the offer, well, not so fast. We have to also go to court, get it approved, and go through the auction process. So maybe somebody will outbid the offer you received in the auction, maybe they won't. And some people are reluctant to make offers because they know that it has to go through auction. So sometimes that makes it more difficult to find a buyer, but other times it's actually worked out okay. So it's not always the same outcome.
Okay. If we're talking about this complex outcome, what's the most simple, most direct way to avoid having to have your assets go through probate?
There are a few different options, but the gold standard is a revocable living trust.
Okay.
And a revocable living trust is like their will, essentially. It says what happens to your assets when something happens to you. But there's one important distinction. With a trust, signing a trust is not sufficient as it would have been with a will. You also have to take the additional step of retitling your assets to the name of the trust. And when you do that, and if something happens to you, even though you don't exist any longer to sign documents,
right,
the entity of the trust still exists, and you've already appointed who can manage the trust when you're no longer around. We call that the trustee. And that trustee can step in and sell the property or distribute it to your heirs or do whatever else that needs to occur almost instantaneously.
Immediately, yeah, and we love that. Now, in terms of the cost consideration for that, depending on if it's simple or complex, what's the general range that you see for implementing these kind of trusts? How long does the process take? How do you usually get that started?
Well, it's all over the board. Depending on where you go, it could be relatively low price or astronomical price. I can't really speak for others, but you know, at our firm, it's typically like $7,500 or something like that. It's much less cost, obviously, and much less delay than having to go through probate.
Yeah.
At our firm, again, typically it takes about a month from beginning to end to get it wrapped up. Sometimes a little less, sometimes a little longer, but that's about the average.
Yeah, and that's way more cost effective than having to go through probate and have to deal with all the drama. I mean, you're talking about instant power. A trustee steps in, they're able to keep everything moving forward. You're not waiting a couple of years. You've got everything kind of planned out. We'll talk more about those details in another video that's coming up. So let's dive in a little bit about this concept of funding. So now that you set up the trust, you're done, right? There's nothing more to do? Or is there something, an additional step that we have to consider?
That's the clear difference between a trust and a will, let's say. And the way I try to describe it to people is by comparing it to a bowl. You may go to Bloomingdale's and buy a beautiful bowl and invite guests over for dinner and bring out your bowl. But if it's empty, people are going to leave hungry. Just having the bowl in and of itself is not sufficient. You have to actually put the food in it. And in the same context, the trust in and of itself doesn't do anything. It only is effective to the extent your assets are placed into the trust. And so when you put assets into a trust, you don't lose any revocable trust at least. You don't lose any control over it. It's still yours. It doesn't change your taxes. It's just the title that changes from your individual name to the name of the trust. And that can be assets in California or Alaska or any other state. It doesn't make a difference. In the United States, you can form a trust anywhere you live and also transfer assets in other states into that trust.
Yeah, and so to be clear, when we're doing the income tax return and you have a trust and it's the whatever, revocable or living trust, the tax return, at least the 1040, doesn't really change at all. It's considered to be disregarded for tax purposes. It doesn't even have its own EIN. It's borrowing your social security number in order for filing it. We call those grantor trusts, right?
But there could also be irrevocable grantor trusts, but a revocable trust doesn't have any tax returns. It doesn't have any annual costs, like $800 fee to the franchise tax board, anything like that. It's just important to make sure that after you create the trust, going forward, your assets are held by the trust.
Yep. Now, very last consideration, because we're in California here, we are in a state which, if you're not aware, property tax does not get reassessed annually based on the fair market value. Most other states will have the assessor kind of come in there, and every year they're going to keep assessing. And if the properties keep moving up in value, then guess what? You're paying more and more tax. But back in the late 70s, they passed Prop 13 in California, and property taxes can only escalate at a rate of 2%, and they only get reassessed when there is a sale event.
Change in ownership.
Yep.
That's correct.
And so let's talk about how this impacts. You inherit the property, you're one of the children of the decedent. What happens in this situation?
Well, 5 years ago, they passed Proposition 19 in California, and essentially that changed some of the rules. And under the new rules after Proposition 19, when a child inherits a property, if it's a principal residence and the child resides in that principal residence, up to $1 million of reassessment is excluded. Anything above that still gets reassessed. And if it's a property that's not a principal residence for both the parent and the child, there is no exclusion any longer, and it's a 100% reassessment. And that's whether you have a will, joint tenancy, or a trust, the same rules apply across the board. As a result of this, I'm going to switch gears a little bit, and I know that your clients are typically real estate investors.
They are.
I want to highly, highly recommend that if you're purchasing a property that is a property that you wish to keep for the long term, and you wish for your family to inherit it and keep it, you consider purchasing it under an LLC, not under your name. We could have the LLC owned by a trust, but ideally the property should be purchased under an LLC. For whatever reason, there is this obscure rule. If a property is purchased under an LLC and then it eventually passes to 2 or more children, the property taxes won't change. Whereas if you buy a property and you transfer it to an LLC that you own and you pass away and it goes to your children, it does get reassessed. Why that distinction? Not entirely sure, but that's what it is. So if it is a property that you wish to keep long-term and you wish for your children to keep it, I highly advise you to consider setting up an LLC, pushing the issue with your lender and your escrow and saying, I don't want to change title the day after escrow. I want to acquire it under the LLC. And that could potentially have incredible tax ramifications for your children down the line.
Yeah, and to be clear, I mean, in the commercial world, you're always going to be able to close in an LLC. It's extremely unusual that they'll ever say, no, it must be in your own personal name. When it comes to single family homes, that's going to be a little bit trickier. It is possible to close a single family home that you purchase for your own primary residence into an LLC, but the amount of lenders that are willing to do that kind of narrows down to a smaller range. It's worth looking into, absolutely, and that's a fantastic tax saving strategy down the road.
Also, duplexes,
Yeah.
fourplexes.
Yeah.
There you can still get residential loans for it, even though it's a rental property.
Yeah.
But we advise you to consider the LLC. Another benefit of that is that since you purchase on the LLC, your name will never be on the chain of title.
Yeah.
I'm not saying that people can't put 2 and 2 together to figure out who owns it, but it's a lot harder. And just the search, it's going to be more difficult for them to see your name.
Yeah, that's common practice. You're not going to be able to search for Beyonce, for example, and look at what property she owns. I guarantee you it's behind a layer or two of LLCs. It's for that reason alone. She doesn't want you coming knocking at her door asking her questions about her next album. I hope you guys found this to be really informative. This is a fantastic area to plan around. You have to consider what's going to happen to your property afterwards, especially as you're building your real estate empire. And if you want your kids or any other heirs to be able to take your property free and clear without many problems at all, then you've got to consider these estate tax issues. And this is the guy you want to hire to be able to do that.
Thank you.
So I hope you guys really found this informative. If you have any questions at all, our contact information is right here. And you can feel free to reach out to us at any time if you'd like to know more about how to plan for real estate on your eventual death. Thank you so much for watching, and look forward to seeing you in our next video.